Okay, good morning, everyone, and thank you for attending my talk today. My gratitude goes to Dashokar Maura and the CBS staff for organizing this very stimulating conference and giving me the chance to exchange ideas with such knowledgeable colleagues. As we all know, and this very conference is a great example, mindfulness and meditation programs have made their way into the wider society, namely with therapeutic and well-being purposes. The characterization of these programs as secular or religious is not only a matter of scholarly interest, but has clear legal repercussions. Since many of such programs are originated and developed in the United States, which presents a model of separation of church and state, I would like to examine how mindfulness programs fit within the framework of the religious clauses of the American Constitution. Particularly, I will focus on whether such programs, despite their alleged secular character, might constitute a covert form of Buddhist indoctrination, often referred to as stealth Buddhism, and even so, if they may still be regarded as constitutional. Well, here's a roadmap for today's talk. First, I lay out the legal and constitutional background within which we may identify different areas of relevance for mindfulness programs. Secondly, I will present an overview of the relevant Supreme Court decisions that need to be considered, and spoiler alert, there is no specific decision involving mindfulness yet, so there is a lot of speculation and relative cases we need to look into. I'll review the three major scholarly perspectives on the religious and secular characters of mindfulness, and after that, I'll take a more empirical approach and undertake a comparison between the features of mindfulness programs and Buddhist contemplative practices. Finally, I'll invite to consider the deeper cultural and constitutional myths behind critiques like stealth Buddhism and propose my own conclusions for discussion. Well, in the American Constitution, religion is treated both as something that cannot be established or imposed by government, and this is usually referred to as a non-establishment clause, and something that should be freely exercised by citizens, and this is usually referred to as a free exercise clause. This implies that Buddhist-based meditation or mindfulness programs may have a different constitutional treatment depending on this secular or religious character. Here you can see a list of relevant areas where this may be relevant. Within them, I would like to focus on two specific contexts: schools, since it involves minors, and prisons, which involves inmates. And children and inmates are both groups of people particularly vulnerable and thus entitled to a special protection. As advanced earlier, mindfulness programs have not been directly challenged under the Constitution yet, so we have to look into relevant decisions involving the religion clauses. In this regard, several U.S. Supreme Court cases have defined how religion can and cannot appear in public institutions, particularly through the design of tests. For the context of schools, Engel v. Vitali found that the recitation of a prayer by students, even if non-denominational and voluntary, was unconstitutional. Again, a school setting, in this case public aids for religious schools, originated the very famous Lemon Test. Here, constitutional legislation is expected to comply with three criteria. It must have a secular purpose, it must have a neutral effect on religion, meaning neither promoting, not hindering religion or impeding religion, and a non-excessive entanglement, meaning administrative interaction overlap with religious institutions. Another important device, the coercion test, was also created for the school context, pointing to the special vulnerability of students who might be subtly pressed to participate in religious activities. As for cases involving the prison context, several cases have emphasized the need to accommodate religious needs and practices of inmates, including Buddhists. In any case, the closest decision directly involving meditation is Malnak v. Yogi. What was under scrutiny here was a public school curriculum teaching transcendental meditation combined with the science of created intelligence, which rely heavily on neo-Vedantic elements and ritualistic components. The judges admitted the difficulties of determining what a religion is for the scope of the Lemon Test and found that the soteriological goal and the presence of ceremonies, spiritual teachers, and sacred texts were clear indicators. The program was invalidated, being classified as religious under the Establishment Clause. More importantly, more relevant maybe for us, Judge Arlene Adams' concurrence opinion suggested that transcendental meditation might be constitutionally permissible if taught merely as a technique without theological content and rituals. More recent Supreme Court decisions have established that a court-ordered participation in Alcoholics Anonymous programs with religious overtones, many of them in the US have a clear Christian orientation, is unconstitutional. So this could jeopardize similar court-ordered participation in Buddhist-based programs. It also found that yoga as a physical activity is secular and that is permissible. And it has also reiterated the need to accommodate religion in prison. In the case in here, it was the beer for Muslims. The length of the beer is regulated in prisons for security measures. And we could extrapolate these effects, for example, for Buddhists. We can think about the possession of certain meditation objects as an exception to forbidden personal items. If we move on to the domain of academic speculation, scholars have taken three main positions on whether mindfulness programs are religious or secular. Some claim they're secular by design, others claim they're inherently religious, and a third group believes it depends entirely on the context. And this, I think, this quite aligns with the presentation of Professor Matt Mahan beforehand. So, yes. So the first view emphasizes that mindfulness programs are therapeutic, evidence-based, and devoid of doctrine. So authors like Rosser and Cullen and Karin argue that since the delivery is neutral and their values are broadly humanistic, these programs need to be considered constitutional. The second view, championed by Brown and Engel, argues that mindfulness inevitably transmits Buddhist ethics and metaphysics, even without rituals. In this regard, Brown criticizes what she calls a self-Buddhism, where spiritual values are sneakily framed as secular well-being, as an unlawful endeavor, or so she thinks. The strategic code switching, sometimes they would use Dharma words, other times they would use science words, the Buddhist training of teachers, and the non-neutral characters of the practices on therapies are identified as indicators that mindfulness programs are actually religious, and therefore they have no place in public schools or institutions. If we move on to the third view, presented by scholars like Judge and Zeller, it claims that constitutional character of mindfulness depends on the framing, the audience, and the setting. So it would be a prudent stance to avoid abstract judgments on mindfulness and assess programs on a case-to-case basis. And following that thread, to test these claims, I think it is useful to try to identify the key elements of mindfulness programs and compare them with those of Buddhist contemplative practices. Well, here I have identified the main mindfulness programs operating in schools and prisons, and I have tried to compare them with practices belonging to three major Buddhist traditions. In particular, I have looked into the following items: the structure of a typical session, the physical elements that are present, the presence of religious objects or rituals, the concepts conveyed, the framing of motivation, framing of goal, and finally the structured training. Well, sorry for the very cramped slides. I have tried to put a lot of information there. These tables were created using official program materials that these organizations have and academic studies as well. And of course, due to time, we won't have time. We won't walk through each chart individually in detail. Instead, we will focus on the final table where I try to highlight key distinctions between secular programs and Buddhist practices. Well, this is a comparison of mindfulness programs for schools in Mind Up, Calm Classroom, and Inner Explorer. These charts shows the main programs used in prisons, and it is interesting to notice that the first of them openly admits Buddhist inspiration or the Buddhist spaces, which might cause certain problems, I would claim. And here is a chart when you can see the representative religious Buddhist practices from the Theravada tradition, Zen tradition, and the Vajrayana tradition. These are, of course, very selective and schematic, but I think it's still representative. Okay, here we go. So here's a comparative chart I was referring to. The table shows how secular programs typically avoid rituals, have secular goals, and use normally a psychological framing or a well-being framing. Buddhist contemplative practices, by contrast, are embedded in religious cosmology and typically aims at liberation or awakening as the ultimate goal. However, some concepts and values at times overlap, such as compassion or non-attachment, for example, which is where arguably concerns about the stealth Buddhism would persist. What I would like to argue here, and this is the main thesis of my presentation, is that what lies behind these accusations of indoctrination What I will try to argue here is that the accusations of indoctrination and therefore unconstitutionality of Buddhist-based meditation programs would be two myths. One, which I have called that secularism is value, or secularism as value-free, and that religion, the second one would be that religion is unidimensional. Regarding the first one needs to acknowledge that all philosophical stances and educational or therapeutic programs transmit values. None of them are, nor can they be, neutral by definition. And the values promoted by Buddhism can be regarded as civic virtues from an American constitutional point of view. At the same time, personal growth scenes a common byproduct in people participating in programs and activities with a humanistic orientation. May they be meditation, counseling, or volunteering. So if people become interested in Dharma because they have practiced mindfulness, that doesn't necessarily to be a case of religious indoctrination, I could say. Every time we stop and think and engage in humanistic activities, somehow something seems to happen to us and that leads people in different directions. Different studies show that actually Christians usually have their own Christian faith reinforced when they engage in mindfulness practice, as here we have seen some notable examples. As for the second myth, meditation or mindfulness do not need to be disassociated for Buddhism in order to legally be accommodated. Religious traditions are complex systems that include doctrines and rituals, but also universal ethics and useful techniques. Secular versions of meditation developed under the umbrella of Buddhist modernism do not need to exclude or undermine the religious versions of meditations. I would like to conclude that both secular and religious versions of Buddhist meditation are lawful parts of the public space under a constitution granting a separation of church and state. Mindfulness programs, even if susceptible of incurring in self-Buddhism, do not constitute a case of religious endorsement, and so do not present a case of violation of the Establishment Clause. They may coexist with and must be clearly distinguished from Buddhist contemplative practices, like the Buddha Dharma practice in prisons, which are protected by the Free Exercise Clause. Both may be, in any case, easily challenged, considering the current composition of the Supreme Court and the heated political climate in the United States. If we care for and value their existence, we should be ready to fight for them in the constitutional arena. Thank you very much for your attention. I look forward to your questions. Thank you very much.